Hi, good evening, everyone, and welcome to another edition of our Justice and Peace's guest speaker series. Today, we are very happy to be joined by the chair of the Law Society Tribunal there, Malcolm Mercer. I was going to say law school for some reason. The LS there stuck in my mind, but certainly a very distinguished career there in many different facets. So perhaps maybe Malcolm, you can tell us a little bit more about your background there, and certainly being previously serving as the treasurer. I mean, being a bencher, being partner at various other and being on various other members of other boards there. Can you maybe start by telling us a little bit more about yourself?
Happy to do that. I'd like to be able to say that it was all planned and thought out, but as I look back at what I've done, it's mostly a series of sort of happy accidents on the way through life, but it's worked out pretty well. I started as an engineer in the early 1970s, late 1970s. And as I sometimes like to say, I saw no future in computers, so I went into law. My background was as a software engineer in the late 70s. So I went to law school, finished and called to the bar in 1984. I joined what was then McCarthy and McCarthy, what is now McCarthy Tetro. And I stayed there from 1984 to 2000, showing a real lack of imagination. Through that time, I did lots of different things. I worked as a litigation associate and litigation partner, doing lots of commercial litigation, a fair bit of real estate, a fair bit of insolvency, a fair bit of shareholder disputes, and as well did medical defense, civil defense, and professional responsibility. By, I guess, the early 2000s, I went into management in the firm and helped run the litigation practice group for the firm for the country, which was then about 225 lawyers, so not a small firm. I finished that in 2016. 2006. I'm losing decades. And went back to practice in part, but became general counsel for the firm, which was a new role. And that was interesting because it was the legal ethics and regulatory compliance of a large firm of lawyers. And I had no background in that, but I knew a lot about the firm and people thought I was a pretty good lawyer. So I learned about legal ethics and regulation through that, became involved in the Canadian Bar Association, ended up chairing nationally the Legal Ethics Committee. I ran for bencher in 2011 for the first time. McCarthy's had a long history of having benchers in the firm going back many generations. And Tom Heinzman, who was one of the seniors, my seniors at the time, decided he wasn't going to run again, so I did. And became very involved in that from 2011 through 2020, chaired a number of committees, was involved in a number of projects, things like alternative business structures, contingency fee agreements, rules of professional conduct. Then by 2018, decided to run for treasurer and was successful. I did that for a couple of years and finished in June of 2020. The pandemic had just arrived. It's hard to remember in retrospect, but that was the end of my term. And at the same time, my time with McCarthy's came to an end. We have mandatory retirement, and I was perfectly happy not to go back to what I was doing before. So I took some time and did a number of things that I enjoyed doing, and then this opportunity came along, and I started as the chair of the tribunal in November of 2020. It's a 4-year term, maybe renewable if people want me to continue and if I want to continue. But that sort of takes me to where I am today.
Okay, so let's start there with the tribunal there, because one of the things, I mean, actually this week my students are learning about the Law Society Tribunal, and some of them got a chance to watch some of the virtual hearings. So maybe you can start there and tell us a bit about kind of the background there and maybe we can start with what are the matters that tend to come before that tribunal? What do you see the most in terms of complaints of lawyers and paralegals and how that process works?
Yeah, so it's useful to start by talking for a moment about what the tribunal is. And we are an independent tribunal made up of adjudicators. We decide disputes between the Law Society and licensees or license applicants. So while we're closely connected to the Law Society, because the Law Society is always a party on one side, on the other side, a licensee or a license applicant, our job is to be neutral. Our job is to be impartial and to be a place where those disputes are decided. Nobody at the Law Society is entitled to try to influence our decisions. If somebody called me up and said, hey, this is before you, I want you to do X or Y, or I think you should do X or Y, I would hang the phone up. Assuming it wasn't Zoom, I'd hang the Zoom up if it was Zoom. But nobody tries. Institutionally, it's understood to be an independent process. That's not always the way it was. Back in the 1990s, it was a discipline committee, and convocation was the ultimate decision maker in discipline matters. So it's a big change over that period of time to a independent and reasonably separate tribunal. So what do we deal with? We deal big picture with three types of cases. The biggest volume is conduct applications, where professional misconduct or conduct unbecoming is alleged. And we decide whether or not misconduct is made out. And if it is made out, we determine what penalty order should be made. I'm guessing that's about 2/3 to 70% of what we do. The second big category is licensing applications. And that probably comprises about 20%. And those are mostly cases where somebody in their background has done something which gives rise to a good character issue. And we have to decide whether or not, looking at the whole person and looking at what's happened since that prior misconduct, whether in effect that prior misconduct is a bar to being licensed. And the third category is capacity, issues of mental health or physical health or substance use. And unlike the conduct matters, which are, did you do something wrong? The capacity matters are not intended to be punitive. They're intended to be remedial, and they're intended both to protect the public by not having people providing services that they don't have the capacity to provide, but as well finding whether or not restrictions might work, or more often finding out whether or not rehabilitation and treatment can bring somebody back into practice. So those are the three big categories. So I'll go back to the conduct applications because that's what you asked me about before I talked about two other things. In conduct applications, there's quite a range. One of the common ones, and your students would be well advised to listen carefully on this, is something called a failure to cooperate case. We have 40 or 50 cases a year out of, say, 160, 180, where the Law Society is investigating something because they've got a complaint or because they've learned of information. They ask the paralegal or the lawyer for information or documents, and the licensee doesn't answer or doesn't give a complete answer or answers slowly, and thereby frustrates the investigation. And that's a big volume for us, and where you don't get an answer by the time of the hearing, it usually results in an indefinite suspension until there's an answer, plus a 1-month suspension the first time. It goes up after that. So, my advice to students is if the Law Society is asking you in an investigation for information, you should understand that it's pretty high risk to ignore it or not to answer because you think you know better. That's one big category. Books and records is another. Failure to maintain books and records, failing to properly account for trust monies. That's more true for lawyers than it is for paralegals, but it's an issue. Failure to serve, taking on a matter but not getting it done. Unfortunately, where people mess up, they start lying to clients about whether or not things were done properly as they get embarrassed. And so failure to serve can turn into issues of integrity. Conflicts, not common, but maybe 10% of cases have conflicts of interest in them. The most serious are questions of dishonesty. So taking trust monies without entitlement, knowing assistance, more for lawyers than for paralegals, in transactions that are fraudulent or dishonest. Those are the sort of cases that cause you to lose your license to practice. And so I guess all I want to say is there's a pretty big range. Some of them are about dealing with the Law Society. Many of them are about dealing with clients. Many of them are dealing with courts and third parties raising issues of honesty and integrity.
Now, let's start with one in particular there, the failure to respond. As you said, there's such a lot of cases. I mean, a lot of times licensees may be afraid, to say something, right? So what would you say in terms of that situation to avoid that from happening?
Well, it's not exactly analogous, but it's sometimes said in politics, it's not the misconduct that gets you, it's the cover-up. And there's a lot of truth to that. It may well be that whatever happened won't necessarily, once it's understood, lead to a discipline proceeding. But if you don't respond, that will lead to a discipline proceeding. So if you're only looking at it as a matter of self-interest, you've got a much better chance of coming out of the investigation with a clean record if you cooperate, because there'll be a prosecution if you don't. And as well, as a practical matter, the Law Society is not out to get anybody. If you've stolen funds, it's a different matter. But if it's sort of ordinary failure to serve or you've made a mistake, the Law Society is more interested in turning things around and finding a way to sort things out. It may involve a caution. It may involve something other than that. I guess if you really are frozen, my advice is to get some advice, whether it's from a colleague or somebody expert in the area. Overwhelmingly, people, when they do things on their own without advice, they make bad choices, they get scared, they make dumb decisions, they get frozen. That's true not just in Law Society proceedings, it's true when you're in a shitty position with a client or somebody's taking pot shots at you. I'm a big believer, especially with paralegals in smaller firms, that building up a network that you can rely on to talk things through, to go for help, to go for advice, to have a coffee. All of that is helpful and important. But getting frozen, your head in the sand, does you no good.
And maybe another one related there, I guess, for students in particular, is as they go through the licensing process, is the good character requirement, and sometimes again similar. That you mentioned, it's not the conduct, but it's the cover up, right? Is that, well, hey, no one's gonna. I don't want to mention, in 1985, I had a little run-in with the police, or maybe even something like being fired with cause, which is one of the things that you have to check off. And then they just put no, and then one thing leads to another, and it's not the issue of maybe what had happened back then, but the fact that in 2022 you're answering no when you should be answering yes. So maybe you can talk a little bit about that in sort of the same kind of vein.
Yeah, no, it's a very good question. In licensing applications, ordinarily the issue is current good character, and it's worthwhile realizing that, I won't have the numbers exactly right, but maybe there are 20 or 30 of such cases each year, including lawyers and paralegals. Think about how many thousands of lawyers and paralegals are licensed each year. So the odds of ending up in a licensing application at the tribunal are pretty low. And there are lots of things that people have done which have been disclosed to the Law Society. And the Law Society looks at it gets some information, decides, fine, we're not going to make an issue of that. Sometimes, though, there are licensing hearings. Not usually, but not uncommonly, there's a second issue in a licensing application, and that is, was there a deliberate withholding of information on the licensing application form? And so the licensing bylaw says, if you deliberately mislead or fail to disclose if you're asked the question, if that's the conclusion, you can't be licensed. It doesn't matter whether or not you're a good person otherwise. It doesn't matter whether or not you've rehabilitated yourself. It doesn't matter whether it was a small deal or a big deal that you deliberately misled on. That's a complete bar to licensing. And so it's very silly not to answer the questions in a straightforward way, because if you do, there's a high probability that things will work out. If you don't and you're found out, then there's a certainty that things will go badly. And I can think of two cases recently. One where a paralegal applicant was found to have misled. The hearing panel never went on to consider whether or not good character was shown, but it was simply an end because they found it was misleading. And another very interesting one decided by the appeal division 2 or 3 weeks ago, which was a paralegal who was licensed now a decade ago, was found to have misled in his application a decade ago. And he has had his license revoked after a decade of being in practice as a paralegal. And that must be devastating. You've put your life into developing a career, developing a reputation, and it's taken away years later. The appeal panel concluded there was no discretion. It was simply once deliberate misrepresentation was shown, that was the end of it.
And maybe we can backtrack a bit then on just kind of the process there. Maybe you can give us like a Law Society Tribunal 101 on what happens, like regardless of, I guess maybe you can pick whichever one. Let's go with we're talking about good character. So what happens where that gets flagged maybe, and how it ends up, you mentioned the appellate division there, right? That how does it get all the way there? Can you kind of just give us an overview?
Yeah, so why don't I give you a quick tour both on licensing and on conduct. Licensing applications are pretty straightforward. All of your students will, I assume, make a formal licensing application to the Law Society. They'll fill out the application forms. If anything is disclosed that requires investigation, the Law Society will investigate. If they discover that there was a misrepresentation, that'll trigger the process as well. Most of the time, they'll have a look at what the application is and look at the warts, and they won't do anything about it. They'll simply issue the license. But the Law Society Act says if the Law Society is going to refuse, they can't be the final decision maker. It's got to be the tribunal. So they file a notice of application with the tribunal. It comes to us. We have usually pre-hearing conferences as we try to come to agreed statements of fact, try to sort out what needs to be litigated, what doesn't need to be litigated. And it ultimately comes on before a 3-person panel. In the case of paralegals, there'll be a paralegal, a layperson, and a lawyer. Panels of 3 decide these things. And it looks a lot like any other trial. You'll have evidence led by the Law Society, evidence led by the paralegal, cross-examinations on evidence in chief. The civil standard of proof applies. So as hearing panels, we're deciding what happened on the balance of probabilities. And we typically have to find, was there a misconduct in the past, and what has happened since then? What is the reaction to the past? What rehabilitation is there? What insight is there? And we then hear closing submissions, just like in any other trial, and we go away and make a decision. So that's what licensing looks like. Conduct is different because in licensing, people bring the question to the Law Society. In conduct, that's not necessarily true. Most conduct issues come to the Law Society because of a complaint, but that's not the only way. As your students will know, there's an obligation to report, and as well, the Law Society reads newspapers and has decisions brought to their attention. Judges can refer matters to the Law Society. It doesn't matter where they come from, but the Law Society receives, this number isn't exactly right, but it'll give you a sense, about 5,000 things each year, many of which aren't within the Law Society's jurisdiction. The Law Society is not a civil court, doesn't deal with negligence claims, and as well, people are unhappy for all kinds of odd reasons. But maybe 3,000 are within jurisdiction. And so those 3,000 go to the investigation department of the Law Society. The investigators will ask questions of the complainant, will ask questions of the licensee, may make third-party inquiries. And most cases get wrapped up. Sometimes they're not founded. Sometimes they're not serious enough. Sometimes a caution letter is the right answer. A variety of different regulatory responses. Maybe 150 to 200 a year go to what's called litigation services, and that's where the prosecutors live. They then work up the case. They go to a ventures committee called the Proceedings Authorization Committee and get permission to bring a conduct application. And then they start one by filing a notice of application, again with the tribunal. And we have very much the same process. We have pre-hearing conferences to try to narrow the issues. Once it's ready for a hearing, we have 3-person panels. The first thing the panel decides is, was there professional misconduct or conduct unbecoming, which is conduct in your personal life. If there is misconduct found, then there's a second hearing on what the penalty should be. And the evidence there is usually shorter. Sometimes there's good character evidence. Sometimes there's medical evidence. But once that evidence is in, submissions are made, again, all on the civil standard of proof. And the hearing panel decides, having found misconduct, they decide what the penalty should be. In either stream, conduct or licensing and capacity as well, there is an appeal right. So if the licensee or the Law Society doesn't like the conclusion of the hearing panel, we have an internal appeal division. And so there can be appeals to the appeal division. In the case of paralegals, a 5-person panel with, my memory is 2 paralegals, 2 lawyers, and a layperson. I may be wrong on that. I have to check each time I assign the panels. And there's a further right of appeal after that to divisional court. And there's a further possibility of leave to appeal to the Court of Appeal. Leave is usually not granted, but occasionally it is. So it looks like full natural justice. It's a civil standard of evidence, and you've got 2 levels of appeal as of right, and then a 3rd and 4th, I guess, to the Supreme Court of Canada, if permission is granted. In my time, I've seen in Ontario 1 case go to Supreme Court of Canada, which is Mr. Groy's case.
Yeah, I was just going to say, I talked to Mr. Groy earlier this year, and I was wondering if there was anything else that has gone even to the Court of Appeal.
The last case that I remember from the Court of Appeal was, I think it was last year, and it was Mr. Diamond, who was found to have engaged in professional misconduct by failing to cooperate, by not answering investigative inquiries. He appealed all the way up to the Court of Appeal, and his appeals were dismissed all the way up to the Court of Appeal.
Okay, so I mean, I think that's great. Thanks, first of all, for the overview there of the process. And one of the things that I would be amiss to mention is because a lot of my students were one of their assignments is to virtually attend a tribunal hearing, and over the last 4 to 6 weeks, I think they've been attending a number of the law study tribunal hearings, and they're happening virtually. So maybe you could tell us a bit about kind of what when that came about and how the process has been compared to when they would be in person at Osgoode Hall.
Yeah, so we didn't do virtual hearings by Zoom prior to April of 2020. We had hearings mostly in person, entirely in person for hearings, although motions and conferences could be done by telephone. We had witnesses sometimes and parties sometimes coming in by telephone. So we had some remoteness, but we just did not have the technology in place. And I think that's the same as the rest of the world, really to do effective Zoom type hearings. I wasn't chair of the tribunal at the time, David Wright was, but we'll all remember March 13, which was the day the world shut down. By, I'm going to say, April 20th, the Law Society Tribunal started to do Zoom hearings. And, we've done really well. We lost a little bit of volume in 2020. We were down, we typically decide about 180 cases a year. We were down 20 or 30, so it created a bit of a backlog. But in 2021, we completed the same number of cases as we received. So that's pretty cool. We were able, in a completely new environment, to effectively deal with the cases we have. And I think it's all good because if you think about it, unlike, for example, summary hearings in Toronto, where the witnesses and the lawyers and the judges and the accused are likely all in the same geographic place, we're a province-wide tribunal. So we deal with paralegals in Ottawa and lawyers in Thunder Bay and witnesses in Windsor and adjudicators spread across the province. And everybody came to Toronto until March of 2020. Since then, we've been able to not require people to travel, not require people to pay for overnight accommodation, not to pay the cost. Maybe lawyers and paralegals don't like this if they're providing representation, but they love it if they're party litigants. You don't have to pay travel time for counsel or representatives. And, the truth is, for anybody who's caught up in one of these things, if you're not in downtown Toronto, it doesn't help your practice much if you've got to travel to a hearing. You lose, you're going to lose some hours and lose some revenue. Some people argue that it's not perfect, and of course that's true. If we could all be in person all of the time and there was no cost or inefficiency associated with that, why wouldn't you be in person? But I believe, having done lots of hearings, that the hearings are fair. I can see some cases where it would be better to be in person. Cross-examination is probably not as effective where you've got a serious credibility issue or a serious issue of fact. If you can't see the person react, if you lose something by the wobbles of Zoom from time to time, maintaining effective control in a cross-examination can be more difficult. And, there are ups and downs. But I think it works really well. And my hope and intent is that we continue to maintain the savings for everybody and for the environment that exists by doing things remotely. There'll be a case for in-person hearings, but I hope it doesn't become the assumption.
Yeah, I mean, I think certainly as we come back, and I've had so many starts and stops there, who knows when it's going to be a full start, but that maybe there's a potential for an option, right? That the party can look at whether it makes sense to have it in person. But again, as you hit the nail on the head, that you could have, especially now with remote client, like you've been getting clients, you could be in Thunder Bay and the client could be in Ottawa or even beyond beyond Ontario, right? That you could be providing services like on an immigration matter or something like that too. They could be
Absolutely.
now. Yeah.
One of the things I did before becoming chair of the Law Society Tribunal is I did cases for the Immigration and Refugee Board in the Immigration Appeal Division, and it was the norm to be dealing with cases internationally. So we were doing it by telephone before the pandemic, doing it by video after, and it was just routine to be able to deal with a marriage case or a residency matter, dealing with somebody who is in Afghanistan or India or in the Middle East, wherever. And I'm absolutely persuaded that those hearings went well, that we were able to sort out to reasonably effective what the truth was.
Now, one of the things I definitely wanted to ask, because one of my students was writing about it. First of all, is there duty counsel or like assistance there for paralegals or lawyers if they're accused, right? I mean, do they have the benefit of someone who can assist? And is there anything beyond that there's a process for being able to tap into?
So we have volunteer duty counsel that provide limited assistance. And there are two different groups of duty counsel. One of them is in what we call the summary hearings. And I told you about failure to cooperate. That's mostly in a summary hearing, single adjudicator, sorry, and they come on quickly with no pre-hearing conferences. There are a number of duty counsel who will assist people in that stream. Duty counsel at what are called proceedings management conferences. And those are, you can think of them as speak to court or assignment court in other contexts. And there is always a duty counsel present, and their name, contact particulars. Actually, I'm not sure that's strictly right. If people want to be in touch with duty counsel, they can contact the tribunal, and they'll be put together prior to the proceedings management conference. And the duty counsel sticks around afterward. Those are 9 o'clock every Monday morning, and they stick around for a couple of hours after that. And they don't act as full representatives, but they provide some guidance, some legal information about the process. If there's a need for a referral, they'll provide that. So these are all volunteers, not funded, and limited assistance. Last week, Convocation started or approved a new program where for the failure to cooperate cases, the head in the sand cases, we're going to fund duty counsel just before they get prosecuted to give the lawyer or paralegal some advice. Importantly, to figure out whether or not there's a mental health issue, because we don't want to be prosecuting people that aren't answering because they're not well. And to help the head in the sand people to understand that head in the sand is a bad tactic, and as well to provide advice as to rights and responsibilities. So the Law Society will fund an hour or 2 or 3 in those limited cases. Otherwise, we don't have funded counsel. Legal aid doesn't cover lawyers and paralegals in discipline proceedings, unlike the doctors where they pay for insurance. It's not technically insurance, but it looks a lot like insurance from the Canadian Medical Protective Association, which provides assistance for doctors who are before the college. That doesn't exist in the tribunal world. Theoretically, there is the possibility in the right circumstances of ordering funded counsel, but it's only theoretical. Before we started, you mentioned to me a case that I had decided now about a year ago, where I concluded it was possible in the sense that jurisdiction exists, but there hasn't yet been a case where it's been ordered. So I wouldn't count on it, and it would be quite unusual for funded counsel to be ordered.
Perfect. Thanks for sharing about that. I think for one particular student, I think that they'll really benefit from that answer there, because that's what they were looking into. Now, in relation to the tribunal there, um, what in terms of, you mentioned the conferences beforehand. I mean, how often do you reach kind of or I mean, I don't know if you're necessarily party to it, obviously, but the law society and the individual come and say, oh, well, we've been able to resolve the main issues, and maybe it's a matter of what's the appropriate punishment. How often do they go to like the full hearings, or how often do you see more resolutions coming about?
Yeah, it's very common to reach agreements. We call them joint submissions, where the parties agree they settle on an agreed statement of facts. The licensee agrees that there has been misconduct, and they negotiate a penalty. And often mostly that happens in pre-hearing conferences with the assistance of an adjudicator. So I do pre-hearing conferences, as do 5 or 6 other adjudicators. Part of what we try to do is see whether or not we need a hearing to sort things out, or whether or not the parties can reach an agreement sometimes with our assistance. It's not uncommon for the law society or the paralegal to say, "Hey, Mr. Mercer, what do you think is likely to happen?" And I always tell people I don't know with any certainty what would happen. I can tell you what I think, and you're free to entirely ignore what I think, but I'll give you the benefit of it. I would guess, I haven't looked at it recently, but I'd guess probably a third to 40% of cases are settled in that way. It doesn't mean, though, that the panel has to accept the agreement. The panel has to be satisfied that there's misconduct. And so if I'm on a panel, I'm going to look at the agreed statement of facts. I'm going to listen if there's evidence, and I will decide if there is misconduct. It's pretty unlikely I'll disagree, but could happen. And if the penalty is a problem, then we follow, for the hearing panel, we follow the criminal law as set out in the Anthony Cook case, which is that we're only entitled to reject an agreed penalty, a plea agreement in the criminal context, if it's unhinged from the circumstances, is contrary to the public interest. And so if it's just we don't like it, or we don't agree with it, or we might have done something different, that's not enough. It's got to be a big problem before we have the authority to say no. So agreements are overwhelmingly implemented. Sometimes the pre-hearing conference panelist sits on the hearing panel, which helps give some predictability. And the parties have the benefit of knowing that an adjudicator has been involved in the process, and where asked has given opinion. There are 2 cases currently which are involve joint submissions. One, a case decided just before the holidays, in which a joint submission was rejected, and we'll see what happens there. And I'm right in the middle of another one that I won't comment on, but we reserved on the question of whether or not we're going to accept the joint submission, and we'll see how that plays out.
So are the options either to accept it or reject it? You can't basically substitute in a penalty greater or less than what's been there, or do you have the powers?
Yeah, it's complicated and depends on the circumstances. If you follow Anthony Cook, you first have to give the parties a good opportunity to persuade you that you shouldn't interfere. That can include the parties saying, "Hey, there was a problem with the evidence. This witness wasn't available," or there was this frailty. It may look like too good a deal, but it isn't really when you step back. The panel then has to decide if it's inclined to reject or accept. If it rejects, it's in some cases, following Anthony Cook, it may be possible to withdraw the agreement, withdraw the guilty plea, to use criminal language. But if the joint submission is rejected, and if the admission of liability is not permitted to be withdrawn, then the hearing panel is entitled to make its own decision as to what the penalty should be. and clearly should ask the party for further submissions. The parties are both going to likely support a joint submission, but once it's rejected, they may not have common positions, or the positions may change. So procedural fairness requires hearing from them.
Yeah, I mean, actually, for some of my students, I think they have in their ethics classes some similar kind of scenario there, where they may come to an agreement on maybe that there was misconduct, but not necessarily on what the penalty should be, and that's what you kind of laid out. There would be submissions from the law society and submissions from the licensee as to what the appropriate punish would be, and then the hearing panel would then make a decision as to which of them or anywhere in between it should be.
Yeah, we have lots of sort of partial settlements. We have lots of cases where it's agreed there's misconduct, but it isn't agreed what the penalty should be, and that's fine. The hearing panel likely finds misconduct where it's agreed, and then there are evidence and submissions on penalty. Quite common.
Or even maybe a step back is maybe they don't agree, whether it's through one of the conferences or an agreed statement of facts, that they can agree to some of the facts. Maybe they don't have a certain witness that can be brought in, or they don't need to bring that witness in because they agreed to maybe that this happened, and the law society's position, well, this amounts to, let's say, professional misconduct. The licensee's position that it doesn't, and then they would make those submissions. So do you see kind of, even if you can't agree to misconduct or agree to all of the circumstances, that reduces obviously the need for a lengthy hearing?
Yeah, absolutely. It's very common and encouraged to agree on what you can agree on. The tribunal doesn't want to force people to agree on things they can't agree on. That wouldn't be right. But it's practically important that people agree on what there really isn't a dispute about, because at the end of the day, there are costs orders, and this can be expensive. And the general proposition is that if someone is found to have engaged in misconduct, they should pay costs. And if you think about it from the perspective of the paralegal profession, there's no magic bank. There's only licensees' fees each year. That's what funds the prosecution. That's what funds the tribunal adjudication. And so the policy has been that if you caused all of this to happen because of your misconduct, you pay costs. That can be very expensive. And so not disputing what you don't need to dispute, even if you want to fight the case, is a smart thing to do. And I also think that in the right case, showing that you're prepared to agree on things that ought to be agreed can make you more credible on the rest.
And one of the questions here that came up was, you mentioned criminal law, and in criminal law, the standard of proof is beyond a reasonable doubt. What is, let's say if the law society has to prove misconduct, what is sort of the standard that they have to prove it on?
Yeah. So the Supreme Court of Canada, in a case back in the late 2000s, said that in Canada there are only two standards of proof. One is the criminal standard, and the other is the civil standard. The Law Society, as a regulator, the Law Society Tribunal as a regulatory tribunal, applies the civil standard, not the criminal standard. And so misconduct must be proven on the balance of probabilities, not beyond a reasonable doubt.
Perfect. And another thing there that especially comes up with students and licensees is they often employ non-licensees, right? And what happens in situations, I'm sure there's been cases recently even where the violation maybe of the rules of professional conduct is done by a staff member at the law firm or anything. Like, how is that kind of dealt with in terms of matters that come up at the tribunal?
So I guess the answer is yes, it certainly happens. It happens that employees have done bad things and licensees have paid a price for it. Analytically, the way that you think about that is if you look at the bylaws, licensees have an obligation of direct supervision of the people that work for them. And the people that work for them are only entitled to do some things, Obviously, some things require a license. Some things can be done under the direct supervision of a licensee. So not uncommonly, what happens where an employee has done something that's a problem, not uncommonly, the case is that it's a failure of supervision. Of course, if it was a case that the licensee knew what was going on, that's more serious. But it can be very serious where essentially you've left somebody to carry on their own without undertaking the supervision, which is part of your license obligation. And you can expect that if there is a real problem by your staff, by your employees, and you haven't been paying proper attention, that's your problem.
And I see another question here about scope. And, there's obviously for paralegals, there's only certain things within their scope that only lawyers can do. Do those types of things also come before the tribunal, and how do they look at that?
Yeah, so the paralegal conduct rules require that paralegals practice within their scope. And so it's not highly common, but the tribunal hears cases where misconduct is alleged for practicing out of scope. So we have to decide as a practical matter what the bylaw says, what the licensee did, and whether they match or don't match. It's not our business, it's Convocation's business as to what scope should be. It's our business to take what's been decided and apply it. And I say that because I don't want to get sucked into questions of family law licensing, which is all out of my purview. It's not for the tribunal to decide policy issues like that. That's for Convocation.
Yeah, and I think that's the other important thing is, people don't realize, obviously, the Law Society Tribunal and the Law Society, as you pointed out, are distinct, right? You're not the judge, jury, and executioner, so to speak, of the licensees. And maybe you can talk about, obviously, the importance of procedural fairness and keeping them distinct, in that the tribunal is separate, right? That you can make decisions that go against the Law Society, and the importance of that for our the regulation of lawyers and paralegals.
Yeah, no, that's exactly right. I think about it as, maybe I'm thinking too much in the old Law and Order show, but I think of Convocation as being the legislature or parliament. It's the place where policy decisions are put into effect in conduct rules or in bylaws. It's for Convocation to make policy decisions. The Law Society staff in the professional regulation department, those are the investigators and the prosecutors. They're the ones who receive information, investigate potential misconduct, and prosecute it if it's appropriate to do so. They are kept separate from the tribunal, and they're kept separate from Convocation. There is a firewall between policy and investigation and prosecution, just in the same way, and think about Alberta right now, where if a politician got involved in a prosecutorial decision, that'd be a problem. Just in the same way, the benchers in Convocation shouldn't be involved in prosecutorial decisions, except through PAC, which is authorized to decide. And in the same way, you'd be very unhappy if the politician or the police officer or the Crown had secret meetings with the judge. And so it's fundamentally important that as adjudicators, we decide independently, and we decide on the evidence before us, and we're not consulted about cases other than in the open light. Now, we are different from judges because Convocation appoints the adjudicators, so we're not totally independent. Benchers pretty much are entitled to be adjudicators, and there are non-bencher adjudicators as well, about half and half. Convocation appoints both. Convocation generally takes the chair's recommendation on appointments. So we are connected to Convocation in that way, but once the adjudicators are appointed, we are to be independent, we are to be neutral, and we have a code of conduct which reinforces that's required, and I think we do it. As a matter of optics, it's an interesting question whether we should be further removed. It's an interesting question whether benchers should adjudicate at all. In a perfect world, you wouldn't have politicians being judges, but maybe in a self-regulation environment, which is the way we regulate the legal professions, maybe that's a good practical midpoint. Not very interesting necessarily to your students, but being a procedural geek, I'm interested in all of that. You raised the question, and the last thing I'll comment on before coming back to you is procedural fairness. The classic case in that respect is the Baker case, which concluded, and all the cases which followed have concluded that potential loss of license gives rise to high levels of procedural fairness. And so, fundamentally, you're entitled to know what you're alleged to have done. You need to have notice to be able to respond. You have participatory rights. You have a right to counsel, not a right to funded counsel, but you have a right to counsel, right to participate. We have Stinchcombe level disclosure. The Law Society is required to disclose all evidence that it's gathered that's relevant, helpful, or hurtful to the prosecution. And as well, you're entitled to an independent adjudicator who is neutral and in respect of whom there's no reasonable apprehension of bias. So all of those procedural protections exist. And in a real sense, we look a lot like courts, although we're not. We're an administrative tribunal in a self-regulatory context.
Perfect. So thanks again for taking the time here and joining us and sharing all about the Law Society Tribunal there. I mean, I'm sure I could hopefully in the future come talk to you about the Immigration and Refugee Board or your time at McCarthy's. There's so much here, and certainly very appreciative of you taking the time to talk to us. Perhaps if you have any final words of wisdom for the students and anyone listening, maybe about how to avoid finding themselves before the Law Society Tribunal, and certainly any other advice you can offer. And thanks again for joining us today.
Well, thank you. I appreciate the opportunity. The only thing I would say in closing was something that I learned before I went to law school, but fits as an answer to your question, which is, if there is something smoldering and smelly in your closet, it doesn't get better by ignoring it. Things get better dealt with if you address them. And that's just practical, but it's true in two other respects. One, people will respect you if you deal with matters straight up, including admitting error. And the second is, if you've got any sense of self-preservation or morality, the longer you fret about something that you could have dealt with, the longer it hurts. So I think dealing with your problems and not hiding from them is good life advice. It's also good professional advice.
Perfect. So thanks once again for taking the time and joining us. Thanks for all the students for tuning in, and take care, everyone.
Thanks, JP. Bye.